Well, I think given we have so many students in our audience, maybe the best place to start is if you could tell us a bit more about how you went from a degree in ancient and modern history to a career at the bar. What motivated your choice of...
Well, it was easier in those days because you didn't have these huge loans around your neck. But having said that, I was quite eager to work as soon as I finished my history degree. I went to the careers advisor at Oxford University, who sized me up and said that she thought a career in marketing fast-moving consumer goods would be the best thing. And I was very obedient in those days. So I said, well, what are fast-moving consumer goods? And they said things like biscuits and sweets. So it sounded all right. So I went to a course with United Biscuits at Heathrow Airport for 3 days, learn how to market biscuits. And at the end, though I think there were about 25 of us on the course, the other 24 were called in one by one, given their travel expenses and offered a job. And I was called in last, and I was given my travel expenses. So that was a little hard, and I cast around a bit for something else to do. And I'm afraid it was my father, who was a teacher, who said that he'd always wished he'd been a lawyer, and why didn't I think about that? I didn't know any lawyers. But I took his advice. I didn't much enjoy the study of law at first, but there was a solicitor's firm in the town that laid on advocacy classes. And so I went to practice cross-examining in the evenings, and then I started doing a bit of mooting. And then I discovered European law, which I really enjoyed and felt enthusiastic about. And I think that's the stage at which, rather late in the game, I started really wanting to be a lawyer.
But you didn't go straight into the bar. You worked at the European Commission. You spent some time as an academic. You worked as an overseas lawyer in Washington. Could you tell us a bit about those experiences, how they shaped your practice?
Well, yes. I mean, a year in Washington was wonderful. I mean, I went there actually because I had a girlfriend in America, but I told them that I wanted to learn about the American legal system, and that seemed to do the trick. So I got 9 months there, and I was then dumped by the girlfriend. So emphasis was on the law. But it was a firm, and it sounds a bit like sort of DLA Piper of America. It was a firm with a very strong pro bono practice. 1 in 10 of all their new files were pro bono at no charge to the client. A firm called Covington & Burling in Washington, D.C. And it was good for them, and it made life interesting there, and it also was a good recruitment device for them, because you could earn a bit more money by going to a big New York firm, or you could go to a firm like Covington and actually do some really interesting and rewarding cases as well. So I think that was sort of good all round. And it was particularly useful for me because I was doing some litigation, some competition law, antitrust as they call it, and the way of working in America is very like the way that was just developing in Europe, in Luxembourg, in front of the European courts, where the advocacy is mostly in writing, the hearings are relatively short. And that wasn't something at the time that anyone really knew how to do in England. We were used to not having skeleton arguments, much in the way of written preparation, everything being done on your feet over a period of days. So I think I learnt skills there in particular. And then by going to spend a year or 6 months in Brussels, I suppose I got some inkling of how the European Union, as it now is, worked, and that was useful as well to bring back for a European practice in London.
And that kicked off your European practice in London. So as a junior barrister at Brickell, you were David Vaughan's pupil, is that right? Or?
No, but I was his regular junior for quite a long time.
And that brought you straight into the Factortame case, which went on for a very long time and was a real pivotal case in European law.
Yes, and Factortame was one of my first briefs. I've still got, I should have brought it along. Zahra's got some visual aids, and I haven't, but within a few months of coming into practice, we had an order from the High Court suspending the operation of an Act of Parliament, which I don't think had been done since about 1610. So that was pretty exciting. The clients were exciting too. They weren't very good at paying because, of course, they couldn't practice their trade of fishing because they'd been told that they couldn't fish because they were Spanish. And we didn't mind not being paid, but when we'd been doing it for about 2 years, we did begin to mind a bit. And the solicitor, very shrewd solicitor, he could sense we were getting a bit unhappy, so he said he'd like to take us out to dinner. And he hired a minibus and equipped it with gin, and we didn't know where we were going. Turned out we were going to a place called the Manoir aux Quatre Saisons in Oxfordshire, where I've never been since, but it was a very smart restaurant, where we had a very good dinner. And on the way back in the minibus, we pledged our undying allegiance to the Spanish fishermen, whether we were paid or not. And we ended up doing the case for about 12 years. And it was, of course, do you still study it? Do you all study it? One thing, I wish someone would do a doctorate, because the discovery, as it was then called, in that case, is astonishing. The government had to produce all the documents relevant to their decision to pass this act. They even disclosed their legal advice. And there's everything in there, from Mrs. Thatcher ranting on in cabinet for hours about these terrible Spaniards, to the complaints of the chap who painted the names on the boats, complaining he couldn't spell all these funny Spanish words. And there's a little sort of snapshot of how Britain tried to get to grips with Europe at the political level, at the industrial level, and of course at the legal level, where we had to get used to this system of law that had primacy over our own. They are absolutely fascinating. We managed to get them declassified, these documents. So if anyone wants to do an interesting PhD, they are available for that purpose.
I just wanted to read out a quotation from you in this book, Faces of Law, which contains photographs of notable people in the law. And you said European Union law aims ambitiously to provide both the ground rules for the peoples of our continent to live harmoniously together and a framework for Europe to project itself to the outside world. For all its imperfections, it is the most advanced expression yet of the international rule of law. Trips to argue cases before the European Court of Justice in Luxembourg and the European Court of Human Rights in Strasbourg are testing, but often inspiring as well. Is this what inspired your long career in European law?
I think I was inspired by, I hate the mustiness that is still associated with the law in England, the wigs and the protocol and the funny language people use in court. I mean, you soon realise that it's not really the bit that matters, but it is off-putting at first. And what I liked about European law was that it was modern, and it was a system in development, and it was being constructed really from first principles. And it was no good just going along to the European Court and saying, well, this is how we've always done it in England, because the judge you're speaking to has probably been doing it in Denmark on a completely different basis, or Greece, or Czech Republic, or somewhere else. So what I really liked about it was the newness of it, really, and the accessibility of it, the fact that it had been constructed recently and was still in development. And so many big questions have to be answered. I mean, when you talk to Americans about practice in European law, they will say, well, it's like being a Supreme Court advocate in 1820 or something. You know, some of these big issues are being litigated for the first time. I think that's really what I found interesting about it. And yes, I suppose to some extent I'm still quite idealistic about Europe. I know this is very much a minority view in this country, and I'm certainly not uncritically in favour of everything it does. But when you look at the past this continent has had, and you look at the strides that have been made in the last 50 years, and the way that all the courts in all the countries actually pretty much accept the rulings of this court to which all contribute and which all more or less trust, I think it is a pretty inspiring thing. And the other way I look at it is, we're what proportion of the world's population in Europe? You know, maybe 8% or something like that, and probably a declining proportion. We do have some values in common, it seems to me. And if those values aren't influential in the world, then which values do we prefer? You know, do we prefer values associated with China, with other parts of the world, or do we have something that is worth at least standing up for and continuing to have as a dynamic part of the global dialogue? And I think we do have a lot in common. I can travel in another European country, read a newspaper there, and think, oh yeah, we've got that issue too. Well, that seems to be very much how we're trying to deal with things. Even in the US, our great partner with whom we have a special relationship, you can read newspapers sometimes and think, my goodness, what on earth is all that about? So yes, I'm an enthusiast for Europe and also for European law.
Beyond the possibility of the in-out referendum, what do you see as one of the key issues facing Europe in the coming years?
Well, as to in-out, I don't think it really is in-out. I think we're already partly in and partly out. We don't participate in the major policies of the euro or Schengen or parts of justice and home affairs. And I think, I'm afraid, the perception over there is that although they appreciate our contributions, they too can see we're not fully committed to it. And for me, the question on that is, where are we going to end up? You know, are we going to stay the UK, sort of mostly in? Are we going to become Norway? Are we going to become Switzerland? Are we going to become Turkey? Or, as I suspect is more likely, you know, are we going to negotiate some other role for ourselves? In terms of other big issues, and it's a very broad question, but I think Europe, you know, has to decide where it can be effective. And traditionally, it's been very much an economic union. It's been strong on trade and on internal regulation and so on. But I think it has to start projecting itself to the outside. It's true we have a common foreign and security policy that probably doesn't amount to very much. But if you ask people in Europe, and not just in countries like Belgium, but in pretty much all countries in Europe, do you think it would be a good thing if there were a common European foreign policy? Most people will say yes. So one will never get there entirely, but it seems to me in terms of defining Europe in the global setting, whether you're talking about trade or whether you're talking about security policy, environmental policy, or indeed security policy, we've got a long way to go, and it's very important that we make our voice heard.
Okay, well, moving on from your work at Brussels and Luxembourg to Strasbourg, over the course of your career, you've acted in a number of cases, a significant number of cases in Strasbourg. To begin with, for the United Kingdom, so acting for the government, but also for the governments of other countries and a great deal of claimant work as well. Do you think that having a mixed practice, that acting both for governments as well as claimants, has informed your approach to this area of law?
I think it's a good thing to act on both sides if you can. I think the great thing about the criminal law in this country is that, on the whole, people do, or have done. How all this is going to survive the decline of legal aid, I don't know. But I mean, I sat as a criminal judge for 8 years, just three weeks a year, but I was always impressed by the way that counsel would cooperate to solve a problem. So if there was an issue about whether something in a witness statement was hearsay or something, all I had to do was say, I'll give you 15 minutes, counsel would sort it out between them. And the reason they could do that is because the prosecutor had probably been defending the previous week, and the defender had probably done a bit of prosecution. So they basically understood each other's problems, and that helped them present the case in a more moderate and sensible and cooperative way. And I think that's true whatever your area of law. I think it's a shame there are some areas of law, and I would take immigration possibly as an example, and there are certainly exceptions to this, but equally there are a lot of people who would only ever appear on one side or the other. And the risk about that is you get into a mindset. You get too government-minded or you get too claimant-minded. I think you're a better lawyer if you've got the flexibility of mind to see it from both sides. After all, the judge sees it from both sides. The court has to hear both points of view and be conversant with both. And I think your chances of persuading the court are better if you're in the same position.
Okay. Well, moving on to the future of our relationship with the European Convention of Human Rights. This morning's Times, I don't know who saw the front page, this morning, dangerous inmates to be stripped of human rights. And it discusses the Conservative Party's outlook, if you like, the Tories' proposals for the Bill of Rights, and it includes things such as European Court of Human Rights rulings to be ignored where wrong. So I think the way they put it is that they should be advisory rather than binding. And they also address particular judgments that they don't like, which led to a scathing commentary from Lord Panic in the paper. But also, when this was dealt with in the public law event hosted by Court Chambers, you also addressed the proposals. And I think one of the troubling things that came out of it is that not only a particular case is being picked on by the Tories, but they're also being misrepresented, if you like, to make a particular point. And I think that the case in particular was the ban on life sentences, and that the ruling of the court was misrepresented in the proposals. And you were then often quoted, or you were quoted by several people as saying that any QC-level lawyer supposedly involved in putting the proposals together ought to be ashamed of himself. Would you like to elaborate a bit more on your concerns?
Well, I don't think I can get political about this because I'm obviously politically neutral in the independent reviewer capacity. But of course, people do have a habit sometimes of misrepresenting the position, and Strasbourg is a very easy target. I mean, I'm a great believer in the Convention on Human Rights. I'm a great believer of in UK adherence to that convention. But I think we can't afford to be smug about this as sort of human rights-minded people. It's probably, in the country as a whole, not a particularly popular view. And that may be because a lot of people have been misinformed or brainwashed. But it's also because I think to make the case for the binding judgments of a supranational court, with judges on it from Russia and Turkey and Moldova and Ukraine and all these places. You really need an international justification. After all, we have a Human Rights Act. Even the Conservatives, as I understand it, would propose to replace the Human Rights Act by something that contains all the same rights. And I can sort of understand the point of view. I don't share it, but I do understand the point of view. We have very good judges in this country. They can interpret these human rights with the help, of course, of the Strasbourg Court if they want, but also with the help of our fine common law traditions and what the courts say in Canada and the US and New Zealand and other countries. So why exactly, when they have these human rights to interpret, do we need to entrust the final supervision of that framework to a court with judges from all sorts of places that don't respect human rights, particularly when it can take years and years and years? So the Abu Qatadas of this world wait longer to hear their fate. And I think that is, it is, to my mind, a serious argument, and it does need to be addressed. And you can address it either by saying, well, those judges have a perspective that even our own brilliant Supreme Court judges don't. And I think there is some truth in that, but it's a difficult argument to make. I mean, I would argue that in the terrorism field, there have been cases where actually the Court of Human Rights has gone a bit further than our Supreme Court, and when you look back, you can say, well, yes, they did the right thing. They weren't endangering anybody by the ruling that they made, but they were, in a beneficial way, increasing human rights. It's quite difficult to make the case on the basis that they're all cleverer than Lord Neuberger, because obviously they're not. I mean, they're different, but they're not cleverer. And I think then the other way you have to do it is on the basis that this is an international system. And the way we are part of the convention enables other countries also to be part of it. And because we accept that we're bound by the judgments of the court, well, so, albeit with very bad grace sometimes, do the Russians, the Bulgarians, the Turks, the Ukrainians, the other major offenders. Now, that weighs very heavily with me, that argument, but I could see that it's a difficult sell on the doorstep. You know, let's stay part of this supranational court so that Bulgarians have better human rights. Or I suppose you could say British football hooligans in Bulgaria have better human rights as well, so there's a bit of self-interest in there as well. But it seems to me that it's a supranational court. The arguments for it, now that we have the Human Rights Act, have got to be really international arguments as well. Paradoxically, it was much easier to argue for Strasbourg before we had the Human Rights Act, because in those days it was the only recourse you had. You could contest why gays don't have equal rights in the military. You won't actually get anywhere in England because they don't have the tools they need to decide the case in your favour. In those days, you absolutely needed Strasbourg. Now, you only need it if the Supreme Court, having looked at the Strasbourg case law, has ruled against you. And that is a more difficult sell. But I think it's an important pitch to make, because I suspect if we did fall out of the convention system, others would do so as well. In fact, I rather doubt whether the convention system would survive, certainly in its current form, were we to pull out. And I think that may actually be the agenda behind some of what is being said in the political sphere.
And I thought you made a really interesting point, at the risk of misquoting you here, but in the other event about the way that security forces understand the language of proportionality, that they're now used to this idea. So with your kind of independent reviewer hat on, do you see any disadvantages in losing the convention language that we've now become accustomed to?
Yes, and also advantages in messing around with it. I spend a lot of time in my current job with spies and police, and I was at MI6 for 5 hours yesterday talking about how they deal with getting warrants for intercepts and tapping cables and so on. And if I had £1 for every time they said necessity and proportionality, I would be a very rich man. Now, you can argue about, do they really apply it? But at least they're conscious of it. And when you talk to a sergeant in a provincial police station somewhere and he starts talking about the Article 2 aspects of something he's got to do, well, you think that's quite good. Someone's drummed that into him. Convention's not that complicated. There's only so many rights. The articles have only so many numbers. And I think as lawyers, we often tend to think, oh, well, the point of human rights is going to court and playing with them and getting judges to enforce them and so on. I think you could make the argument, actually, that more useful is the application of human rights in public authorities. It's learning about them, applying the framework, using them as a discipline for good decision-making. And if you spend all your life in the law, you forget that. And people who want to mess around with the convention, or let's renumber it, or let's reword this, okay, if there's a really pressing reason for doing it, let's do it. But otherwise, you very easily confuse people. Any of you who've had to study European law through the various renumberings of the treaties will probably know what I mean.
Well, moving on from there to your role over the last few years as the independent reviewer of counter-terrorism legislation, what can you tell us about the challenges and responsibilities of that role compared to being self-employed barrister?
It's a wonderful job. It's the best job in the world. And if it survives long enough, I do hope some of you will apply for it someday, because it now has a transparent appointment process. But I don't think anyone would invent it now. It would be too risky. It's a sort of shard of independence going right to the heart of the secret state. It was invented in the 1970s when terrorism had just arrived on this island from Northern Ireland, and we had the Guildford pub bombings, and in the wake of that we had our own Prevention of Terrorism Act for the first time, which was to be renewed every year. And Parliament said, reasonably enough, well, if we're going to make an informed decision on how to renew it, we really need to know more about how it's being applied. And since you won't let us, the MPs, read all the secrets, why don't you get someone else you can really trust to read the secrets and then report to us? And that's what happened. They appointed Lord Shackleton, who was the son of the Antarctic explorer and a very independent hereditary peer. And he was succeeded by a variety of other people. In the last 25, 30 years, they've all been QCs. But the idea is to use, I suppose, your forensic skills, talk to as many people as you can, question everybody you talk to, read the secret material, and then report to the Home Secretary, who must lay the reports before Parliament, on what you see. And if what you report is embarrassing for the Home Secretary, then that's just too bad. That's why I don't think anyone would invent the job now, and why it's very important to try and keep it going. And there is some benefit for the government in it, of course, because not everything you say is likely to be critical. And to the extent that I see good practice or good decisions being taken, or I think the Home Secretary has been conscientious or proper or correct in the way she's handled something, then I'm not slow to say so. And we're in such a miserable state in politics in this country where no one trusts politicians that they actually do quite crave independent people saying they're doing a good job, because people might trust the independent person more than just another politician saying they're doing a good job. So there is some benefit in it for them as well. And there has to be, I think, a slight element of combining the criticism with the praise. If I transformed myself into a sort of Shami Chakrabarti, then I think they would pretty soon find ways of marginalizing me and stopping me reading stuff I really needed to know. Equally, if I just lined up behind our brave boys in blue and said how lucky we were to be defended by them all the time, and that was the only note I ever sounded, then I suspect I would completely lose credibility with NGOs, academics, other people who are concerned about civil liberties. So you're at your most influential when you're somewhere near the middle ground, but that doesn't mean you choose the middle ground for that reason. You have to say what you think, and you have to sort of pick your issues a bit so that you don't appear to be all one side or all the other.
Well, looking at some of the issues you've picked, starting with, I guess, the most obvious one, the definition of terrorism, I think you really hit the nail on the head by saying we can tweak the definition here and there, but we also need what you describe as a root and branch review into terrorism. To what extent is it necessary to have a subset of legislation called terrorism legislation? How is terrorism different to other criminal acts? Could you elaborate on that? But also, do you think there will ever be enough political momentum to take a risk like that? You were just talking about the risk of having an independent person have any involvement in this process at all, let alone an independent person advising whether the whole thing is justified. And we can see that, as you described, the genesis of anti-terror legislation, it tends to be in response to a kind of public outrage to a terror attack. And it's a way, cynically, you could say, for the government to look like it's doing something. So do you ever foresee that there will be the political momentum to have a real look at whether terrorism legislation is necessary?
I would rather the word terrorism didn't exist in the law at all. I wrote an article in which I compared it to a magnet which draws people in of all kinds, whether they're academics or whether they're lawyers or whether they're military people or whether they're trying to sell barbed wire, or whether particularly they're journalists who want that evocative, emotional word in a headline, or whether they're politicians wanting credit for keeping us safe. And the trouble with magnets is that if you approach them with a compass, your compass is disabled. It starts spinning around and showing the wrong points. And I think that's a risk that all of us face when we get too close to terrorism. if it's terrorism, everything is different. Everyone must be differently organized. Now, I think there are some features of terrorism which do call for different solutions to specific problems. And I would say that one is the potential for a mass casualty attack on a really huge scale, sort of 9/11 type attack, is such that you can probably justify criminal laws that reach back a little further in time and don't just enable you to punish a conspiracy or an attempt, as in the traditional criminal law, but might justify punishing, for example, an act preparatory to terrorism, as we now have, or the possession of materials likely to be useful for terrorism, if you've got the right mental element in place. So I can see that. I can also see the need, the heightened need where you're looking at terrorism, not to put all the evidence in the public domain. Now, I don't apply that to a criminal trial. In a criminal trial, you have to be able to put all the evidence before the defendant or before the jury. But there may be other contexts in which it is necessary to try and construct a system in which you try to reconcile the requirements of fairness with the requirements of security. But the trouble is, those are very specific comments. And as soon as you coin this word terrorism to apply to a huge range of activity, you sort of create the assumption or the expectation that special rules may apply right across the board. And you end up bringing too much activity into that very special area. And I've written about that, as you said, provoked partly by the Miranda case. Now, I have no particular brief for Mr. Snowden or Mr. Miranda. I'm not one of those who die in the ditch to say that they were doing great work when they stole those documents and when they started to publish some of the results. But I do question whether using anti-terrorism legislation to arrest somebody carrying those documents or to stop somebody carrying those documents is appropriate. And if you look at the way the court had to look at the definition of terrorism to read into it somebody who was suspected of being the accomplice of somebody who was possibly a thief, possibly a spy, but was not in common parlance a terrorist, then I think you get some idea of what I mean. So I made some modest proposals. One has been taken up, actually, in the bill that's going through Parliament at the moment. No one's noticed this, but they have reduced the definition of terrorism-related activity, which is another of these rather sprawling concepts. They don't boast about the fact because, particularly post-Paris, of course, the emphasis is always on toughening things up rather than making them more liberal. But I'm pleased they've done that. I think there's quite a bit more they could do. As for the root and branch review, who knows? When I took on the job, things were pretty quiet on the terrorism front, and people were writing articles saying whatever happened to terrorism. And this government, and again, it doesn't boast about the fact, but it liberalised quite a lot, very unusually for any government. Between 2010 and 2013, a lot of terrorism laws, 4 or 5, were significantly rolled back. Had that peaceful period continued, then I hope we would have got to a point where people said, let's look again at this. Have we got too many of these laws? Are we barking up the right tree? And indeed, is terrorism really the right label? Look at something like fighting abroad. All these people coming back from Syria and Iraq, we deal with them under terrorism legislation. It seems obvious. We've all seen the beheadings and the stuff ISIS gets up to, and obviously ISIS are terrorists under our definition because they're fighting against governments somewhere in the world. Government of Iraq and ironically the government of Syria. That's enough to make them terrorists. But is that actually the right set of concepts to apply to people who go and fight abroad that we're worried about? What if they're fighting for Assad? My understanding is that in Australia, they have Australian Shias who've been fighting for Assad. Now, much more difficult to say that's terrorism if he's fighting for a foreign government. Is this an activity for which the label of terrorism does the job, or do you need something more generic that's addressing the actual problem you're looking at? So I hope there will come a time when we think about those things. I don't think it'll be very soon.
You mentioned several pieces of legislation shrinking or things being made more liberal. And we obviously went from control orders, which were quite draconian, to terrorism prevention investigation measures, or TPIMs, which you've looked at on a number of occasions. But that's an instance where you then felt that actually perhaps we need to reintroduce something that we took away. And here I'm talking about the relocation powers. So that's the power to move, or I don't know how you would describe it, terror suspect, or how you describe the individual. And their families then given the choice to move with them, and the families report negative consequences for them. by Megapause to move. Now, in September 2004, you conducted an urgent review, and I understand that it was a classified review, so you can't talk about.
Well, I'm trying to get it declassified, actually.
Right. But I mean, what can you tell us about the reasons that you felt reintroducing these controversial measures was necessary?
Okay. Well, the first thing I would say is that I think TPIMs were and remain an improvement on control orders. The most important thing was that you could be kept under a control order indefinitely, whereas a TPIM has a maximum duration of 2 years. There are many other liberalising changes which remain in place. So, for example, there's a maximum curfew now of, I think, 8 or 10 hours. Under a control order, you could have 18 and subsequently 16 hours. You must, under a TPIM, be allowed a telephone and a personal computer. Under control orders, you were allowed neither. There are more relaxed rules for people you're allowed to associate with and to meet. So in all those respects, I think TPIMs are an improvement on control orders. The problem with TPIMs is that they have become unusable because 2 people absconded. You might remember the second one dressed in a burqa, leaving a mosque. And it got to the point where the political risk of using them appeared to make using them impossible, so that they had withered on the vine. Now, you might think, very good thing if they're not being used, and indeed I said that. I think prosecutors, if they do their job, can get people into court and get them convicted on the whole for criminal offences. But there will always be a very few cases when that doesn't happen. And for that reason, it did seem to me, on balance, necessary that the TPIM should remain as an option. And the classic example would be the Operation Overt, the airline liquid bomb plot of 2006, in which I think about 15 people were arrested. There was a sequence of 3 trials, at the end of which most of them were convicted and sentenced to very long life sentences. This was a plot that would have brought down simultaneously possibly as many as 8 to 10 transatlantic airliners. And it was a viable plot. It was intercepted only shortly before it was due to be launched. Well, one person was acquitted, and people have different theories about why that might have been. It wasn't possible to deploy all the evidence in open that they would have wanted to deploy, and often when there are many defendants, it's possible for the evidence to come out in such a way that some are convicted and others aren't. But in any event, the Home Secretary had to decide what to do to keep people safe. Was it acceptable this person should live in a completely unconstrained way, or was it advisable to be able to put some sort of constraints on them, at least sufficient to allow them to be, for the authorities to keep an eye on them? As far as relocation is concerned, I think there are really 2 reasons why. I looked at every control order, I looked at every TPIM, I talked to the families, I talked to some of the TPIM subjects, I talked to MI5 and the police and the Home Office and everybody else who's concerned in their management. And I think there are really 2 reasons. I mean, they're used only in the most serious cases. At the same time as suggesting they reintroduce relocation, I also suggested they put up the burden of proof, they reduce the definition of terrorism-related activity. In fact, I made 10 suggestions, 8 of which were in a liberalising direction, and all 10 were accepted as a package. First thing to say is they wouldn't have accepted all 10 if I hadn't suggested relocation. But I suggested it for practical reasons. Really, the first is association. And the pattern we're seeing with people going to fight in Syria and Iraq, much more so than with people who went to fight in other theatres of war, is that they come from London. And they come from particular parts of London, not just Tower Hamlets. One could look at parts of West London as well, where there's a great concentration of people. Now, you can try and say to people, the alternative to relocation is to say, we want you to stay out of these particular streets where your dangerous associates live, the people we think you've been attack planning with. But of course, if they live near you anyway, it's very easy for them to meet you and associate with you in a very small compass, unless you are invited to move to another town some distance away. And the second reason was absconds, and they had, as I said, become unusable because people were able to abscond. Now, I read the confidential reports on those absconds. They're not going to be made public, but I think all you need really is common sense to see that if people are in an area where they are well connected, they have friends, it might be easier for them to abscond because it's much easier to get false documents, to get assistance in travelling to the port and so on, if there are people around that you know. So it seemed to me you got to the stage where a group like CAGE, the advocacy group for prisoners in the war of terror, were putting out statements saying things like, if you want to escape from a TPIM, you can. And they had been discredited. The Home Secretary didn't dare to use them. They were viewed with contempt by people who were subject or liable to be subject by them. It seemed to me you had to go one of either 2 ways. You either abandoned them or you toughened them up a bit by reintroducing relocation. And with all these people in Syria, the possibility something dreadful might happen there, and a lot of them all come back at the same time, totally overwhelming the resources of our security services. It seemed to me that the better option in this respect was to strengthen them. But still, I think, significantly less onerous than the control orders we had between 2005 and 2011. And I must say that's, if they are less onerous, I don't take any credit for that. I think that is very largely the activities of campaigning groups like Justice, like Liberty, like Muslim Association of Students, a lot of groups making freedom of information requests, taking test cases, lobbying Parliament. These things really do have an effect. And I think in this particular instance, they had a good effect.
Okay, I want to open up to the floor in a minute, but I have two quick questions before I do that. So 2015 looks like it's going to be quite a busy year for counterterrorism. I mean, we opened with the tragic events in Paris the year. We've still got ISIS in Iraq and Syria, Boko Haram and Nigeria committing atrocities. We've got Al-Qaeda in Yemen. And we have some particularly domestic issues to think about. So fighters coming back, British citizens coming back, and the issue of exclusion orders or temporary exclusion orders. And there's also the upcoming election in which your review of the regulation of investigatory powers, or the Investigatory Powers Act, seems to be a frequent issue that comes up in the TV debates. What is your view, or what do you think will be the most important issue for counterterrorism in 2015?
Well, certainly what's taking most of my time is the RIPA review about intercept and comms data. The subject is absolutely huge. I mean, it's packed with complex policy issues, and at the heart of it is how the intelligence agencies and the police go about their work, not only in the field of counterterrorism, but in other fields as well. And it's a fascinating debate because on both sides of it, you have people united in the proposition that the existing law is out of date and unsatisfactory. And you have police saying, we can't read all the stuff that we've been reading in the golden age that we've enjoyed for the last 10 or 15 years. We must have more powers so we can get our hands on more of it. And you have civil libertarians saying, well, hang on, when this act was passed in 2000, there wasn't any social media. Nobody had any idea of the extent to which it was going to be used. So both sides, but the only thing that unites them is the need for change. And it's become very political, certainly within the coalition. And I think, trying to resolve or suggesting a resolution to those different policy issues is certainly going to be my biggest task. And it's a terrifying task, because I'm only a lawyer, one who's brought up, as Zahra is brought up, to argue quite defined legal issues in a very precise and disciplined manner, in which one never has to do anything as vulgar as express an opinion, but simply make submissions on behalf of some client who is pulling the strings behind you. And suddenly to be left exposed in a highly political environment and required to make a series of policy recommendations, some of them with, all of them, I suppose, the legal basis, but often not much more than that, is very tough. In terrorism more generally, I mean, it's a bit like the sort of traditional Christmas adverts you get on TV. I mean, the pre-election Counter-Terrorism Act is a sort of, it's a fact of life, by which I don't mean to suggest that the act is not worthwhile, the bill is not worthwhile. In fact, I think there are a lot of rather useful, rather technical things that nobody ever writes about in this counter-terrorism bill, which do make a certain amount of sense. For example, about the way police can operate at the ports, about the way no-fly lists are compiled, and that side of things. But I mean, the eye-catching measures are certainly the measures that would operate on people going out, should the police have the chance to take their passports away, for 14 days, renewable by a court to 30 days, and temporary exclusion orders, which are no such thing. I mean, they are orders aimed at managing the return of people who are suspected to be jihadis. I think Justice probably take the view they shouldn't exist at all. I'm pretty agnostic about their merits. I think they might have benefits in some cases, but I've chosen to concentrate my efforts on ensuring that if they are going to happen, and it seems to be the settled will of Parliament that they will, they inject proper judicial control into that. And some amendments were lodged this morning by the government, which I think give effect to some recommendations I've made about that.
And finally, reforming the role of counter-terrorism watchdog. We have this proposal for a privacy and civil liberties board, which I think you've been slightly critical of. Could you elaborate on your concerns?
Well, I mean, the proposal keeps shifting. In fact, I was talking to people this afternoon who had a different bright idea about what the Privacy and Civil Liberties Board ought to look like. I'm not against the idea of privacy and civil liberties, quite the contrary. I'm in favour of seeking to inject some privacy and civil liberties expertise into the way Home Office decision-making takes place. And it may be that this is one of the functions of the board. I think my concern was really that, as it's expressed in the bill, the relationship between the board and my own function is not very clear, and what they risked doing is creating something that whose functions sort of overlapped with mine, and whose working relationship with me was not well defined. And which, because of its numbers, probably wouldn't have the degree of security clearance that I had. And my concern was that we might be trading the reality of effective review for the appearance of effective review, and at the same time not addressing the real issues relating to my job that should be addressed. I don't get to review all the counter-terrorism laws. It seems to me obvious that I should. I don't get to decide an annual work plan, so I can concentrate on particular issues in particular years. And again, there are no statutory guarantees that I get to see all the secret stuff, or that the Home Secretary publishes my reports promptly. In practice, those things happen, but I don't think practice is enough these days. I think you need statutory guarantees. The bill as it currently exists doesn't address any of that, and I don't know what will happen, but my strong sense is that we have to watch this space, because there may be more to come.
Right. Well, thank you very much, David. That's enough from me for now. So I will open up to the floor. If anyone's got any questions, you can put your hand up. And I think there's two roving mics.
There are two roving mics, guys. So if you have a question, put your hands in the air and we'll get a mic to you so that everybody else can hear you.
Okay, I think there's a question.
Do ask Zahra questions too. And she really has had a very interesting life, and I think she'd like to answer some of your questions as well. If you don't, then I'll deflect yours onto her.
Okay, here. Sorry, we have a mic.
Sorry, can I just say, everyone make sure they speak into the mic so we can sort of recording what's going on.
Yeah, just a
Thanks for that really interesting presentation and discussion. One of the things which is often said in the wake of massive attacks like in 9/11 and Paris this past month is that there's always a knee-jerk reaction, and laws are passed really quickly without scrutiny in Parliament. They're rushed through, essentially. To what degree would you agree with that? Because I've read, I think, most of your reports for the past few years, but I don't think I've seen any of your any discussion from you about that, about the process in Parliament. Because it reminds me of the famous case A in the Secretary of State for Home Department, when Lord Hoffman said the real threat from terrorism is not, it's not from terrorism, it's from laws such as these. So I was just wondering what your thoughts are on that.
Well, the phenomenon you describe undoubtedly exists. The best example is the Explosive Substances Act 1883. I think there were 4 bombs on the Metropolitan Line Railway or something like that in London, planted by Fenians. This was international terrorism because they'd learnt their trade at the Brooklyn Dynamite School, and they'd been reading this seditious magazine, which wasn't called Inspire, it was called the Irish Liberator and Dynamite Monthly, which was published under First Amendment freedoms in the US. Well, everyone was so traumatized by that. The Explosive Substances Act went through Parliament, all 3 readings, I think in 24 hours. So even by the standards of the DRIP Act 2014, that was breakneck speed. It's not always a mistake. I mean, that act is still in force and hasn't actually been much amended. Another beneficial example, I would say, it might be controversial, after 9/11, the European Union got the European arrest warrant through. Now, that had been kicking around for years. I happen to think European arrest warrant could be improved, but is ultimately a good idea. In fact, it's inevitable if you're going to have a single market with people moving around freely. Of course, the police in Leicestershire need the ability to have someone in Derbyshire report to them if they've committed a crime. It just seems absolutely inevitable, and the same thing within Europe. That was actually a beneficial example. But of course, there are bad examples too, and I think you probably gave the main one. I mean, we're lucky in that our main terrorism statute, Terrorism Act 2000, as the name suggests, was fully debated and in place before 9/11. So that didn't owe anything to the panic factor And partly for that reason, because it was so up-to-date, it was widely imitated in the rest of the world, both in the Commonwealth and also in Europe. But you give the example of detention in Belmarsh, which came in the 2001 Act, which became law 2 or 3 months after 9/11. And I think probably in retrospect we can all see that was a mistake. This bill currently before Parliament, well, I suppose you could say at least its lines were evident before the Paris attack. How Paris will affect the debate on it, I don't know, but I think it's only fair to say that most of its provisions did seem pretty uncontroversial from the fact that it completed its 3 Commons readings before the Paris attack came along.
Next question. Could you just keep your hand up? So we've got. Oh, sorry. Yeah, we've got you.
Actually, a similar question in the same vein as the knee-jerk reaction. I was wondering, what's your opinion? You mentioned the idea of the homegrown threat, and people who've grown up in London but end up fighting in Syria. I was wondering what you thought about, for example, in the Sydney siege, Man Monis, who was the gunman, he was not proven to have any links with Al-Qaeda or IS or anything like that. And so the idea of restricting association, in fact, wouldn't necessarily help in that situation because a lot of people would classify him as a random loony. So how do you, with keeping respect for human rights, how do you control that threat? Because obviously society expects a legislative response.
Well, it's a good question. I'd perhaps like to bring Zahra in as well. I mean, I think the answer is you can't control random loonies without becoming the sort of state that none of us would want to become. I mean, going back to Queen Victoria, she was threatened during her life 7 times at close range by men with guns. And it might have got a little easier to stop that now, but it's never going to be possible to stop everything, and nor is it at all sensible to visit the whole might of the terrorism law on people who are basically mentally ill or disturbed or odd loners. And of course they exist just as much on the far right as they do on the Islamist side. I mean, people associate themselves with powerful movements and for all sorts of terrible reasons. I'd like to be able to say that all terrorists are like that, and they're all just mentally ill and unhinged. Unfortunately, I don't think that's the case. I mean, one of the really interesting parts of my job, which I didn't realize it was going to be so interesting, that I get to go and see people once they've been in police detention for more than 48 hours. I'm only going to see them to see if they've been properly looked after. But the consequence is that I go frequently to Southwark Police Station to meet young men they've picked up on their way back from Syria or Iraq, and who are said to have been fighting, some of whom are subsequently charged, some of whom are subsequently released. And they are remarkably normal people to talk to, on the whole. I'm obviously generalizing. It's often very like the sort of conversation you might have standing in a queue with whoever happened to be next to you. They tend to be young Londoners who share a lot of your points of reference and are not obviously mentally ill, but who might have very strong ideas. And so it's always tempting to pathologize these people and say that they're ill because it's so difficult to accept what they do. Unfortunately, I don't think that's a complete explanation.
I think that the answer has also got to link back to what we were discussing about the definition of terrorism. With the people who plan the mass atrocities are the people that you would want to catch. See what I mean? And you would think, I don't want to take that risk, and I don't want the risk to be out there. And they must have communicated, they must have planned, they may have travelled to train, etc. And why didn't we catch them? I find it very troubling when people react to kind of lone wolf attacks with that same mentality. You think, well, actually, the same day that the Sydney siege happened, on page 20 or whatever it was of the Metro, there was a small paragraph about a mass shooting in a school in the US. It so happened that the insane person doing that doesn't raise an IS flag, but that's clearly, an issue that happens across the world. There are people who use violence for whatever means, and it's not always preventable. And I think it's a bit dangerous when things like the Paris attack happen, when people think, well, how could we avoid that? And, what can we do? How many other liberties can we curtail to make sure that no terror attack ever takes place? And you think, well, we never adopt that approach with any other risk that we face in life. We all hop on planes despite the fact that a few have disappeared in the last couple of years, and we carry on taking that
I agree, and I think as a policy priority, terrorism is unique. You could ask the government, what's your goal in relation to FGM or child sexual abuse or people trafficking or clinical negligence or road accidents or anything you like. And they'll say, well, we aim to reduce the level and bear down on the problem. So when you ask them about terrorism, the aim is no attacks. And it's, in a way, you're almost setting yourself up to fail if that is your aim. There are going to be, sadly, some successful attacks. Now, that's not to say we should complacently sit back and accept that. But it is to say that if you set goals that are unrealistic, you do risk skewing resources and spending too much on some things and not enough on others. And I'm afraid, I think, it's very easy. I wrote in some of my early reports, and I wrote a report of 2012, I gave some mortality statistics, and it's very easy to say, of course, you're more likely to drown in your bath than you are to be killed by a terrorist, or about the same as the odds of being killed by a bee sting, and so on. And all these things are true. But they're sort of true, but they only take you part of the way there. And when you look at something like the reaction to Paris, and of course it's heavily fueled by the media, but it's also a sort of a human reaction as well. You sort of realize, well, perhaps something like that is in a different category. A successful mass attack, which is aimed either at an organ of the state or at specifically the exercise of a freedom that we're used to enjoying. You have to say, well, maybe that's more significant than the same number of deaths from a bee sting. But the media do have a lot to answer for. They're not even-handed in the way they cover these things. I've seen some terrible examples of that, not only in the mismatched way in which they look at atrocities committed by different groups, but also in the sort of language they use when they're dealing with Islamist terrorism. And this whole field is full of symbiotic relationships. One of the closest, I think, is between the terrorist and the journalist, because they both basically want exactly the same thing. I mean, they both want the word terror in huge letters on the front page, and they want us to be very afraid. And I'm not sure what one can do about that. Probably best do nothing.
Thank you. That was really fascinating. I wondered if you could say a bit more about your role, and I'm thinking like how you manage doing something that's kind of quasi-judicial, but also very, very political, or at least it's in a very political area. Like, I know when the amendments to the counter-terrorism bill that you talked about, Nick Clegg was going, these are approved by David Anderson QC. And I just thought, well, really? I'm sorry, I don't know if you can answer that. But, I thought, well, maybe it's more like, well, if you have to legislate, this would be a more sensible way of doing it. But you're not really in a position that you can respond to that. And I just wondered if that makes it difficult or if that affects what you say in the first place.
I think he said he'd sink the bill to which he'd earlier put his name if his coalition partners didn't do what I was suggesting. Yeah. But no, I think the answer is I don't try to be a judge. I try not to make judgments on individual cases. So, for example, all the TPIM cases, I look every year at all the files. I look at the decisions the Home Secretary took. My predecessor actually used to say every year, I would have taken the same decision in every case. I don't say that. I'm a little worried that someday a decision might come up that I wouldn't have taken the same way, and that's the sort of thing that gets used in court. And so I don't think you can do the judge's job. My job is to look at the system. But nor can I do the politician's job. I try to use the legal skills of dispassionately analysing facts, collecting and analysing facts, in order to inform the political debate and the public debate. I'm not a politician. I do talk to them. I talk regularly to ministers, and I talk to opposition politicians as well. But partly that's to inform. So when the Justice and Security Bill was going through, for example, I spent quite a bit of time with shadow ministers, shadow law officers, as well as with the coalition, trying to talk through what I understood the legal constraints to be and what I understood from other people, like special advocates and people who appeared for the subjects of these measures and people who appeared for the government. I met with all of them to try and explain to people some of these very technical issues. But I think if I remember I'm there to inform the debate rather than participate in it, then I'm more or less in the right place. Though, of course, it's not always an easy distinction to
draw. Thank you. Can I draw you out a bit further on the status of returnees? I was rather concerned that some human rights observers have compared returnees to those who fought in the Spanish Civil War. And I would argue that that's a very wrong comparison, because those who went to Spain, some of them did go to fight for fascism, but most of those who went to support a democratically elected government. And so the comparison is wrong. But I'd like your thoughts on another case where British people went to fight in the so-called Israeli War of Independence, which was fueled by terrorism, where British people killed other British soldiers and policemen and massacred Palestinians, and came back to Britain and were not punished in any way, shape or form. By contrast, those who fought on the Spanish Republican side were proscribed when they came back to Britain. They couldn't join the public services, they couldn't join the army, and that was only lifted at the outbreak of the Second World War. So I'd be interested in your comments.
Yes, it's a delicate subject. I think you rather reinforce the point I was trying to make, and that I made in Chapter 10 of my report of July 2014, about needing another legal framework to look at this issue. Because I think trusting to terrorism law and the hope that the people you are needing to punish are those who've been doing dangerous things isn't really enough. I mean, in Australia, for example, they have a thing called the Foreign Enlistment Act, and it's an offence under that act to fight abroad for forces other than those that are on an approved list. I mean, you know, if one takes a view that sometimes it might be acceptable for a Brit to go and fight abroad, then maybe that's how you have to do it. I mean, whether you have a schedule to an Act of Parliament, or whether you allow ministers to sort of keep some list, I don't know. One would be making, no doubt, some very difficult judgments from time to time. But I think if you... I don't think terrorism law is adequate for that whole range of possibilities. I mean, the other one, you mentioned Israel, but I mean, you didn't mention the Brits who go and fight for the IDF, and you hear a lot about that from Muslim groups. You know, how come they punish our people who go to Syria, but they don't punish Brits who go and fight for the IDF? Well, there may be a very good explanation for that, but I'm not sure that saying, well, you're terrorists and they aren't, is necessarily a very complete explanation. I think it may need to proceed more from first principles.
Does anyone have any questions not on the terrorism aspect of David's role? Career-related questions or career-related questions or anything like that? Otherwise, I'm happy to go back to your other questions. Anybody? No? So back to... Oh, there. Okay.
With David Cameron wanting to give new powers to agencies to look into encrypted messages between terrorists, and with Anonymous sort of threatening to wage cyber war on Al-Qaeda, do you ever feel that you're being asked to look at areas that are becoming increasingly complex and specialist, and that potentially even people like David Cameron don't properly understand them? I mean, with the anonymity given by the dark web, I'm not quite sure why these new powers would necessarily be particularly effective. Is that ever a concern of yours, that as a lawyer and not a specialist in cybersecurity, you're being asked to...
Yes, very much so, because key to understanding this is understanding the technical side, how encryption actually functions, how secure it is, whether you can have, for example, a front door without having a back door. And there have been recent speeches from Mr. Corney of the FBI and others suggesting that you can do that. I suppose all I can say is that as lawyers we're used to having to assimilate technical material, even if it's only for the purposes of cross-examining an expert on how quickly concrete dries or something like that. And what I would say about the investigatory powers side of things is that obviously I'm not short of opportunities to hear what they think about these things at GCHQ, but also there are fantastic specialist NGOs. You know, I'm thinking of people like Privacy International. I'm thinking of lawyers who understand the technical side of this very well. And I'm thinking of academics who I have found extremely generous with their time and their expertise. And I'm still on a learning curve where all that is concerned. Hopefully, you know, I will get there in time to road test my own understanding with both sides and produce a report that, from a technical point of view, makes sense. But it's highly polarized. I mean, if it was just a question of understanding something that everybody agreed, it would be easier. But it is a highly polarized world, and you will find technical people with very different understandings of how it works technically.
We have a question.
Thanks for speaking this evening. I guess I just wanted to pick up a point you just made on like the stated objective to kind of defeat terrorism as compared to something like FGM, where it's like reduce. I spent some time in Somalia in December and November, and again, you speak to British officials, and it's one of the places where we send most of our overseas aid to, and the objective is first and foremost protecting UK national interest. And you find yourself in a situation where policy officials, to their own frustration, are often allied with the government, the Somali government at present, who corruption is rife, etc., and there's various governance issues. And in some ways, the same narrative that Al-Shabaab is using against the government is actually, on some levels, agreed with internally, but to vocalize that would almost be to legitimize what Al-Shabaab is saying. So it kind of gets to this issue of where we are trying so hard to defeat terrorism, we're almost making short to medium-term compromises in order to kind of defeat terrorism. And I guess my wider point I was trying to make by that is the question is, you're the independent terror kind of reviewer on legislation. How do you see in 5 years and 10 years where we're going to be with this kind of phenomenon of terrorism? You kind of talked about it conceptually. We wish we could walk away from it within legal frameworks. But it seems to me we're kind of subscribing to this never-ending phenomenon of sometimes where we're supporting governments because they speak a little bit of our language, and yet they're still carrying out actions that might be contrary to some of the values we hold. So it's like these short-term trades between stability versus our values. And I was just wondering some personal reflection on that would be interesting. The extent to which, I know you're looking internally at legislation, but how do we balance some of these issues, as you're saying?
I think that's a very good question, and it goes, as you were suggesting, well beyond terrorism. I mean, it really goes towards a wise foreign policy. I'd like to bring Zahra in on this one too. I mean, it's often said that with the cutbacks in the foreign policy, the Foreign Office, we've actually lost a lot of good regional expertise, and that our understanding of how the Middle East works and how Afghanistan works has been disastrously inadequate. And if you read, for example, Rory Stewart's book about his experiences as the governor of a province in Iraq so I think 2005, 2006, very interesting book. You see this ex-soldier who was motivated by sort of doing the imperial thing and helping govern wisely, who at the end concludes, we were wasting our time. We didn't know what we were doing. And some of the recent books as well about the Afghan war and the going into Helmand in 2006. And there seems to have been an unwillingness to learn from history, and maybe a lack of the wisdom that we used to be known for in our approach to difficult parts of the world. And in relation to dealing with difficult regimes, I'd be interested to talk to you about your experience. I've only touched really on one aspect of this, and this is the difficulties that I know aid-giving organizations, but also peacemaking organizations like Conciliation Resources have in operating in difficult parts of the world. I mean, if you're trying to react to the sanitation crisis in Gaza by providing water purification tablets, and you need a certificate from the Gazan Ministry of Health, does that mean you are giving material support to Hamas? And does that mean you could go to prison in America for 65 years or contravene an equivalent English provision? If you convene a meeting in London of people who belong to the LTTE to talk about Sri Lanka's transition to post-conflict society, are you attending a meeting with a member of a terrorist organization, which is an offense under the Terrorism Act? I can't solve those problems. What I have been able to do is to set up the necessary meetings so that these people, instead of only talking to DFID, are able to talk to the hard security nuts in the Treasury and the Home Office and so on. But lots of difficult issues there. Sorry, Zahra, are you going to comment on that?
Well, I don't know. I mean, it is, as you say, it's a very, very difficult issue, and I think you're back to kind of the grey areas where it's very difficult to be black and white or to say, the British government should have no dealings with any other government that doesn't fully respect human rights, etc., or something like that. And I don't think you can be that black and white about it. However, I think if we are to learn from history, one of the things that we can see over the last decade, at least, or the last 2 decades, is that it's a much smaller world, and we can't sponsor, if you like, state violence in one area of the world or turn a blind eye to it and not expect it to somehow affect us in the short, medium, or long term. And I think we definitely see that with Syria. You know, everyone turned a blind eye to a catastrophe that was basically unfolding before the international community. And okay, they did try to pass various measures, but they tended to be very self-serving measures. So it was about, you know, whether you take Saudi's side or Iran's side, or you Russia or you the US, and it didn't put the Syrian people first, I think, for many years. And that's now turned into ISIS. It's turned into, you know, the primary, I would say, terrorism breeding ground in the world, where any person with terrorist aspirations could fly over and meet others and train and fly back. And then, you know, now we're talking about temporary exclusion orders and that kind of thing. And I think we also, in that globalized world, you know, it also brings us to challenge some of our views. And one of the views, having spoken about terrorism all day, all evening, is that terrorism is kind of an attack on Western values, which I find just really quite shocking, in the sense that I think you say this in your report, but I mean, Iraq is probably the country that is most afflicted by terrorism. Syria maybe at the moment can compete with Iraq, but actually most victims of terrorism are Muslim. The vast majority of victims of terrorism are Muslim. But you have this, you know, if you only look inwards, you can start saying things like, oh, you know, terrorism's out there to get us, and then you get this kind of slightly irrational Western-centric view of what terrorism is and what it's trying to achieve. So I think it's important to take a global outlook, but then turning that to solutions is much more difficult. Are there any questions on this side? I'm just conscious that I'm always looking this way. If we got anyone, I'll take this one here.
Hi, I was just wondering, what direction do you think Justice and Home Affairs and the EU will take in the coming years? Well, and if there'll be further integration in that area?
Well, I hope there is, and I hope we're part of it. Actually, they look to us to give a lead, oddly enough, although we've opted out of some of it. And I think, you know, we've got quite a long way to go. Europe is very good at privacy protection, and there's a very strong element in the Parliament that seeks to make sure that when we make agreements for sharing of data and so on, there are proper privacy protections in place. And if you do have those protections in place, it seems to me to make obvious sense. I mean, surely if this Syria and Iraq demonstrates one thing, it's that this is a European problem and that it's not going to be effectively addressed by lots of countries doing their own thing in their own way. And this is one of the possible objections, in fact, to the exclusion orders. Are you just dumping your citizens, your problem on somebody else? And if we're able to do a better job of sharing information with appropriate safeguards, then I think it's good for everyone. I mean, history shows that Justice and Home Affairs sees fairly halting progress, and I'm afraid the progress is at its greatest when we've just had an atrocity of some kind. And I think you may be seeing, for example, movements on passenger name records. The idea that some basic booking information is available in every EU state when the flight began in another EU state. It seems to be common sense, and it also has a beneficial effect that you're less likely to want to search the person on arrival if you already know the basics sufficient to see whether they're already on your warn list. So I'd like to see more progress in that direction. I think we're a very long way from an oppressive EU superstate. I think we're more 28 countries sort of desperately trying to combine some vital functions and doing it in a slightly haphazard way.
I wasn't suggesting that it was.
No, I don't. I just think you might be.
Well, we've had a number of guests in this series who've recognised that the legal profession is changing. I wonder whether you would have taken the same career in today's profession as you did at the time that it...
Well, when I began, European law was where the intellectual excitement was, I thought. And a lot of young people like me were going out to Brussels, as I did, and coming back, if not with stars in their eyes, at least thinking, wow, the chance to build a legal system, it's the future. You had Jacques Delors, President of the Commission, saying 80% of the laws are going to come from Brussels. and the European Court. And so I suppose for me that was the intellectual excitement. I'm not sure I'd feel that today. I mean, if I'm British and starting off as a lawyer, we're not seeing people in chambers applying to us, on the whole, saying, I want to be a European lawyer. They're saying, I want to do human rights, I want to do public international law, I want to do commercial law, I want to do public law. So I guess I would do something else. But I think the thing about law, and some of you obviously started practice already and others haven't, but I think there's a lot to be said for not being too prescriptive about what you want to do. And sometimes we have people who come and say, well, I want to be a human rights lawyer. And you say, well, there isn't really such a thing as a human rights lawyer. I mean, if you do housing law, then you're going to come across issues that are undoubtedly human rights issues. Same thing if you're doing immigration law, if you're doing criminal law, even if you're doing commercial law. You know, they all have human rights issues. And you've got plenty of time in your career to develop, as I've done. I mean, I've been a bit of a butterfly, and I started doing shipping law before I got into Europe. And I've been going, you know, human rights and terrorism. And I think you've got plenty of time to do that. What you need is to establish the requisite mental disciplines. And it's not about who you know, thank goodness. I mean, it's not really even about what you know. It's about how you think. And if you've learned to think and to express yourself with clarity and with conciseness, then the world is your oyster. And those are skills that you can apply to whatever legal discipline or even non-legal discipline you fancy. So I wish you all well with that.
I think we need to wrap up now. Do we have time for one more question?
Yeah, one more.
Yeah, I think there was one here.
Bring it back onto terrorism, yes again. Given your role in granting transparency to something which, of course, that is very important that we have, what is your opinion on the increased private nature in which counterterrorism is now being acted out? I'm looking at private military contractors, government contracts that maybe go out to private consultancies that are doing counterterrorism work. How does law, counterterrorism law, adapt to the increasing private nature in which that battle, for want of a better word, is being acted out?
What sort of contractors are you thinking about?
There are implementers working across the MENA region on behalf of Western governments. Now, in that respect, I know that there's transparency there because they are audible, they are using Western government's money, so that's not so much the issue. It is private military contractors, perhaps. You look at the way that human rights law is inextricably now linked or crosses over to how we act as a state outside of our borders. And that increasingly has a counterterrorism aspect, well, a huge counterterrorism aspect to it. So how do we now respond to private military contractors and the effect that has on counterterrorism and our ability to adapt to it?
I think you raise an interesting general point about the contracting out of counterterrorism. And I think you saw that most notoriously in the decade after 9/11 in terms of the relationships that our agencies had and other Western agencies had with countries whose standards might have been lower. And one thinks obviously of rendition and of allegations of complicity in torture and so on. And in a sense that might have been one way of farming out the problem, getting someone else to do the difficult stuff who wasn't under the spotlight of an independent reviewer. Completely different example of the same thing. It's always seemed to me that as well as reviewing acts that have terrorism in the title, I ought to be able also to review the immigration laws, which may not be explicitly directed at terrorists, but if you look at the way that they're operated, for example, the way some people are kept for very long periods in immigration detention, and the way if you look at the case of someone like Abu Qatada, how he was hit both by counterterrorism law and by immigration law, and the combined effect of that was to keep him under constraints for very long periods of time. I think it's important to look into that as well. I mean, whether someone like me would ever have the facility to look into the activities of military contractors, as you suggest, I don't know. It seems to me somebody ought to. And one ought to be approaching all this not by virtue simply of the label on the tin, but by the virtue of what's actually happening and what function is being performed.
Thank you very much, David. Thank you, and thank you for all the questions.